Start. The decision of the full bench of this court in the case of Avatar Narayan versus Subhash Chandra within bracket Supra is inapplicable to the facts of the present case. The question that fell for consideration by the court in that case was whether the latter's patent appeal against a judgment of a single judge of this court in first appeal would be maintainable having regard to the provisions of section 100A of the code. In the said case, the respondent had filed a petition for grant of probate letters of administration which were allowed by the learned district judge, Delhi. The appellant preferred an appeal against the judgment of the learned district judge under section 299 of the Indian Succession Act 1925, which was dismissed by a learned single judge of this court. A latter's patent appeal was filed by the appellant against the judgment passed by the learned single judge. The controversy in that case related to maintainability of an appeal against a judgment passed by a single judge in appeal preferred under a special statute. The court held that since the powers exercised by the learned single judge were appellate powers, a latter's patent appeal would not be maintainable by virtue of section 100A of the code. The issue whether the learned single judge exercised appellate powers was not an issue in that case, as indisputably the judgment of the learned single judge in that case was passed in an appeal provided under the Indian Succession Act 1925. The full bench of this court followed the decision of the Supreme Court in Kamal Kumar and another versus Ruby General Hospital Limited and others 2006 7 SCC 613, whereby the Supreme Court had concluded that where an appeal from an original order has been decided by a single judge, then in such cases latter's patent appeal is not available as the same. The order dated 16/9/2013 passed by a division bench of this court in Dr. Morpan Limited and another versus Power Generation Private Limited Supra dismissed the said appeal in limine in view of the decision in Avatar Narayan versus Subhash Chandra within bracket Supra. The said order dated 16/9/2013 neither contains any discussion as to the facts of the said matter nor records any of the rival contentions. The said order does not provide any reasoning as to the controversy involved. It is apparent that the questions whether the powers exercised by the registrar under Rule 3 of the Chapter 2 of the OS rules were exercised as a delegate or not, and whether a single judge exercises original civil jurisdiction while deciding a challenge under Rule 4 of Chapter 2 of the OS rules were neither placed nor considered by the court. The said order thus offers no assistance to the respondent. It is necessary to consider that the scheme and the provisions of the OS rules relate to the exercise of original jurisdiction. The OS rules have been framed in respect of the practice and procedure for the exercise of the ordinary original civil jurisdiction as is made explicit in the preamble to the said rules. The heading of Chapter 2 of the OS rules is exercise of original civil jurisdiction. The same also indicates that the rules contained in Chapter 2 of the OS rules relate to exercise of original civil jurisdiction. If the entire scheme of the OS rules is considered, the perspective that it relates to exercise of ordinary original civil jurisdiction, then it would be apparent that a single judge exercises ordinary original civil jurisdiction even while considering a challenge under Rule 4 of Chapter 2 of the said rules. In this view of the matter, an appeal under Section 10 of the Act from a judgment of a single judge would lie to a division bench of this court. Section 100A of the Code would not be applicable as the powers exercised by a single judge under Rule 4 of Chapter 2 of the OS rules cannot be termed as appellate powers, and the expression appeal in Rule 4 of Chapter 2 of the OS rules is a misterm. Over.